right, sounds good. Well, good evening, everybody. Thank you so much for being here tonight. This is not our regularly scheduled programming. Different day, different time, but we felt like a conversation was necessary. These are uncharted waters that we're wading through. And, we opened this Zoom up less than 48 hours ago, and over 100 people have signed up. So it shows me that it's heavy on your mind as well. So we're really privileged tonight to have Colonel Julie Huygen, who is not only a valued member of the League of Women Voters, but a career military woman. And I'm going to introduce here in just a few minutes. I want to go over just a reminder of what you signed when you register, but also when it comes to questions, please feel free to put questions in the chat. And don't worry about having to be on camera or speak. We are monitoring the chat, and either Jennifer or Kathy will ask the questions for you. So ask away. Just really quickly, a reminder of the disclaimer. You have agreed to not engage in any behaviors or actions that are harassing, threatening, or physically or verbally abusive towards any League of Women Voters member, guest presenter, employee, or member of the public. And you've agreed to not create an environment that is intimidating, hostile, or offensive. So that being said, I want to go ahead and introduce our speaker this evening. Colonel Julie Huygen has a bachelor's degree in government from Harvard University and a JD from the University of Maryland. She retired from the Air Force as a colonel after 21 years as a judge advocate, or JAG. She spent much of her career specializing in international and operational law, but her final assignment was as a senior appellate military judge on the Air Force Court of Criminal Appeals. And tonight we're going to just pick her brain on the state of affairs and the deployment of the military to the protests in domestic protests, both in Los Angeles, in Texas, and then I just heard today that the governor of Missouri is calling up the National Guard this weekend for that state as well. So without further ado, I'm going to turn it over to Colonel Julie Huygen. Hi, Julie. Thanks for being here.
Of course, it's my pleasure and honor, and thank you all for taking time out of your evening to join us tonight. I see I have share privileges, so I'm going to start off with some slides. I'm going to move pretty quickly through them, in part because when I have them up, I can't see you all. So if somebody starts talking to me, my preference would be to see you rather than you look at a bunch of text. But I just want you to see some of the kind of basic background of how I'm going to be answering our questions in a particular context of the most relevant laws that I'll be thinking about as you guys ask me questions when we get to them. All right, so first of all, let me open my share. Give me just a second. And, oh, sorry, I did not first make it. There we go. Okay. So here's the official name, and you'll hear some commentators in particular, especially if they have a government background, especially if they have a background as a government lawyer. This is the term that we'll use, which is kind of the umbrella term whenever we're talking about using the U.S. military in some capacity inside the United States. Because we generally, of course, I guess, have the luxury of a stable enough national history that we don't have recent experience of the U.S. military being used as a military force inside the United States. Disclaimer that always begins every presentation by a current or former DoD employee is that the views presented are those of the speaker and do not necessarily represent the views of the Department of Defense or its components. All right, so we also use the term MSCA, or Military Supportive Civil Authorities, and we're going to talk about what I'm about to talk about. Generally speaking, two basic questions of what can the U.S. military do inside the United States and what can the military not do inside the United States. So just to give you kind of a super basic examples listed here, these are not comprehensive bullet points, they're just examples. So inside the United States, the US military, whatever our status, meaning active duty, guard, or reserve, there are ways in which we can assist civil authorities in the event of a major disaster or emergency. We can be used to detect and monitor aerial and maritime drug smuggling on a regular basis. That's often left to the Coast Guard if we're talking about maritime. But I'm not going to also, actually, let me say that today. Everything I'm going to talk about today does not cover the Coast Guard. The Coast Guard, while it is a uniformed military armed service of the United States, it is in a very different position than the other armed services of the United States, meaning the Army, Navy, Air Force, and Marines. The Coast Guard are separate, not only because they used to fall under the Department of Commerce, now they fall under the Department of Homeland Security, but also because they have all these different authorities than the regular armed services have. We cannot operate equipment for law enforcement. I know that sounds kind of bizarre, but it actually started to come up a lot more once drones became much more common in the US military, but we're still not super common in like law enforcement organizations. Also, for example, of how we do this, not for law enforcement purposes, but the US military has been used both aerial, both planes, as well as drones for stuff like firefighting in different states, particularly in Western states, because we have a reconnaissance or surveillance capability that, of course, most firefighting agencies do not have. What can the military not do in the United States? We cannot participate directly in a search, seizure, arrest, or similar activity, meaning a law enforcement activity, unless very specific authorities are involved. And we cannot perform civilian law enforcement duties, which brings us to one of the most common terms that's been coming up this week with regards to the use of the military in the United States. I'm sure you've heard it on multiple newscasts or podcasts, which is reference to the Posse Comitatus Act of 1878, or shorthanded as the PCA, because we're the military, so we're going to abbreviate everything that we can. This first bullet of whatever, 5 lines, I guess, that is the Posse Comitatus Act. That is the whole act. It is one section of 18 US Code, and that is it. That's the entire thing. And what it basically says is, unless there is a very express and specific authorization to do so, the Army, the Navy, the Marine Corps, and the Air Force, and now the Space Force cannot be used as a posse comitatus or otherwise to execute the laws. All right, which basically means we can't be used to conduct law enforcement. What is a posse comitatus? It's kind of obviously it's a funny phrase to use, but it was the phrase that was in existence at the time the law was first drafted in 1878. So there you go. It means, as translated from the Latin, it's power or force of the county. And it's basically a very old legal concept of being able to basically kind of call together a posse, and a posse being what you think of when you think of a posse, like Wild West days. Let's call up the posse, right? So everyone's going to gather up around the sheriff, I guess every able-bodied man with a gun, and then you're going to follow the sheriff's directions to enforce whatever law the sheriff is looking to enforce. So that is what the military in the U.S. military inside the U.S. cannot be used as, is a posse comitatus. All right. This is definitely a law where the exceptions to it are very important, and they have very seldom been used. And in fact, as we'll talk about a little bit more later, it is currently not, none of these exceptions have been invoked in our current situation. First of all, a couple terms, let me get them out of the way so that you're not confused in terms of how I'm referring to different sections of the military. When in the military, when we refer to the National Guard, we're actually referring to both the Army National Guard and the Air National Guard. If you hear us say like California Guard or Missouri Guard or whatever, What we mean is that we're talking about the Guard in their state capacity. And technically, if you're referring to the National Guard as the National Guard, you're referring to the Guard in their federal capacity. It is very important that we keep maintaining distinctions between when a guardsman is in state status, or what we call Title 32 status, or if they're in federal status, which we call Title 10 status. Why do we use this term Title 10 and Title 32? Because those are the two titles in the United States Code, the federal law, and those give guardsmen different authorities to do certain things or prohibit them from doing certain things based on whether or not they're in state status or whether or not they're in federal status. There is no guard for the Navy or Marines, so we're only talking about soldiers and airmen, basically, when we're talking about Guard. There is a reserve for Army, Air Force, Navy, and Marines. We're not going to talk about the reserves today because they are not a part of the discussion of what's happening right now. In the situation in California right now, you have two different types of military service members. You have the California Guardsmen who have been federalized and recalled to duty. And then you have the roughly 700 active duty Marines who have apparently are still in some kind of, they're getting just in time training. I don't know. They still, last I saw in terms of the open source news reporting was that they have not yet appeared on the streets of Los Angeles, but they have left 29 Palms where they are regularly stationed. Okay. So why do I bring this all up? First, in the context of the Posse Comitatus Act, because generally speaking, the Guard are presumed not to be bound by the limitation of the Posse Comitatus Act because they are generally presumed to be in state status. But when they are ordered to active federal duty, which the California Guard has been in this particular situation, then the Posse Comitatus Act applies to them. So as long as they're under command of the state governor, and guardsmen can do law enforcement. They can do civil disaster response. In terms of the California Guard, a significant percentage of them are trained to be firefighters and kind of fall into the chain of command of CAL FIRE and other state and local agencies inside of California that conduct firefighting. But they can do all of that when they're in state status, right? And so just as background, I will tell you, there's no doubt in my mind that the California Guard and the various elements of the California Guard, depending on where they're normally garrisoned, they all have standing relationships with local law enforcement, be it Sheriff Department, Police Department, California Highway Patrol elements, right? And so they all have regular lines of communication open for this in the event that there is a situation that that the governor decides to recall the state guard onto state duty and have them work with local law enforcement to deal with a particular situation, or local first responders really to deal with a particular situation. All right, we are not there right now. Right now, we are in the odder situation, or the much less common situation, where not only do we not have a situation where the President of the United States has contacted the California governor and asked the California governor to deploy a portion of the California Guard. We're in kind of the opposite or extreme situation where you have, and this is in my lifetime unprecedented. Literally, this has not happened in my lifetime, where the president called a portion of a state guard to federal duty, and in this particular situation, without asking, without receiving the consent, or without receiving a request from the state governor to deploy a part of the state guard and to federalize them. So when a state guard has become federalized, then the Posse Comitatus Act applies to them, and they cannot be used for law enforcement purposes, except for one situation, which I'll talk about later in the briefing. All right. If you listen carefully, when the Secretary of Defense, Secretary Hegseth, was appearing before the Senate committee the other day, he actually has it's the one respect which he has kind of stuck to what some lawyer told him to be very careful to stick to this particular line, which is that the California guardsmen who have been federalized in California right now, that they are not conducting law enforcement and they are respecting and adhering to the Posse Comitatus Act. I can't explain to you why this is the one law they think is inviolable. I honestly can't, because they violated a whole lot of other laws. So it's not clear to me why they think this is such a line they cannot cross, but I am thankful that they are not crossing it as of yet. All right. Why you see the red arrow there is that this provision under Title 10 of the US Code, Section 12406, this is actually the provision of US law, federal law, that President Trump specifically cited as his authority to call up the California Guard without the request or consent of the California governor to perform federal duty. And so laying out here, and again, this came up in the Senate committee hearing, and I'm trying to recall the senator that asked about this, of the Secretary of Defense. But basically, you see the three particular circumstances in which this law, according to the terms of the law, should or could be invoked to justify calling up the National Guard or to calling up a guard force in order to perform a federal duty as directed by the President of the United States or the Secretary of Defense. However, you will see this line in this law, which I included in this excerpt, which is that orders for these purposes shall be issued through the governors of the states, meaning that this law assumes the governor of the state of the guard in question has either requested the calling up of the guard or has consented to the calling up of the guard, right? Neither of which is the case that we're looking at here. And these orders that we're talking about in the particular situation in Los Angeles right now, those orders did not come through the governor of the state. All right, so wrong direction. Okay. National Guard. There is another section of Title 10 that specifically talks about if and when the National Guard can be federalized to be basically to fall under the command of the President of the United States and the Secretary of Defense of the United States. And very important, this particular section, Section 12301, is you can only order National Guard to active duty, meaning federal active duty, with the consent of the governor of the state, because you can't do it if you don't have the consent of the governor. This is a very clear provision in the law, right? And again, there is one exception to this, which is the next slide, and that is the Insurrection Act. The Insurrection Act, first of all, is the one exception to not having the consent of the governor of the state of the guard that you're talking about. It is also the primary exception to the Posse Comitatus Act. The Insurrection Act, therefore, is very important, right? Because it is what the president can invoke, both to not have to be required under US law to get the consent of the governor of the state of the guard that we're talking about. And it is what allows the president to direct US military in the United States, whatever their natural status, whether active duty, guard, or reserve, but including the guard. It is what, if invoked, could allow the president to order the military to conduct law enforcement inside the United States. Very important act. If you kind of like Googled or really LexisNexis, military law review journals for the past like 20 years for Insurrection Act, you will see a lot of discussion about the Insurrection Act because there is a lot of controversy around the Insurrection Act, mostly because experts in the field, which does not include me, do not think it's a sufficiently specific act. They think that it is too vague to to give the president sufficient parameters, whether restraints or constraints, in terms of how they can call up, for example, guardsmen to active duty without the consent of the governor of the state, or how the president could use the military inside the United States for law enforcement purposes, right? Which is the truly like red line that, as a matter of principle, the government entities, including the military, is a red line that we do not look to cross. So what does the Insurrection Act say? The Insurrection Act is actually several provisions inside Title 10 USC. I didn't pull up Section 251 here, mostly because it's not relevant to our current situation, but both Section 252 and Section 253, which you see here in front of you, both of these sections have been discussed in the current situation and are potentially relevant depending on how this whole situation plays out over the coming days, weeks, months, and years, really. And I'll explain why I'm looking at such a long timeline. All right, so first of all, President Trump has not invoked the Insurrection Act. All right, so he right now, because he has not invoked it, remember I told you, he cited section, now I'm forgetting the number, basically that ends in 406, right? That's the section he used, section 12406. That's what he used in his presidential memorandum to call up the California Guard, all right? He did not invoke the Insurrection Act as his authority to do that. He has been engaged in conversations, according to reporting, he has been engaged in conversations about the Insurrection Act for the current situation. And there's been much reporting about discussions, including him, about the Insurrection Act during his first term in office. All right, so there is news reporting, mostly through the New York Times, that when the George Floyd, followed by the Black Lives Matters protests were going on, that he was involved in quite a few conversations about whether he could or should invoke the Insurrection Act, in part to federalize the National Guard and have them fall under his command to go to places that he ordered them to go and to go do things that he ordered them to go do. He never did that, in part because even though he told governors across the country, hey, I'm just waiting for you to ask me for help. In fact, all of the instances in which guardsmen were called up to duty in response to the Black Lives Matters protests and other incidents that followed the killing of George Floyd, those were all governor's decisions. So those were all the governor deciding to call up his or her guard force in order to assist law enforcement with dealing with mostly situations that devolved into riot or where there were incidents of sometimes vandalism, sometimes looting, sometimes assaults on police officers, right? So different factors that governor of that particular state decided to call up the guard of that particular state. And again, the big advantage for a governor is that if a governor calls up his or her own guard force, that governor can have that guard force perform civilian law enforcement duties inside that state. All right. When was the Insurrection Act last used? It was actually invoked by President Bush in 1992 during the LA riots after LAPD the 3 LAPD officers were acquitted of beating Rodney King. But that is not a direct corollary to the situation we're talking about today, because the Guard was involved in that kind of invocation of the Insurrection Act because the governor of California asked President Bush to federalize the California Guard. And that kind of went hand in hand with President Bush invoking the Insurrection Act, not only as an authority to federalize the California Guard, which he did at the request and with the consent of the California governor, but also because it allowed those guardsmen to then be involved in civilian law enforcement, even though they were in federal status versus state status. All right. All right. So the last time a president of the United States has activated a guard force without the governor's request or consent was in 1965. President Johnson was actually involved in quite a few conversations over some period of time with Governor Wallace of Alabama in terms of whether or not, because Governor Wallace had actually activated the Alabama Guard. But so they were already active, all right, and you can see them in newsreel footage, right, before the Selma to Montgomery March. You can see them at certain locations where there were protests happening and whatever. But here's the catch: the Governor Wallace was not using the Alabama Guard consistent with how President Johnson thought the Alabama Guard should be used. Governor Wallace is using the Alabama Guard based on how he thought the Alabama Guard should be used and exactly who is being protected from whom at these civil rights protests, right? So in the conversation between President Johnson and Governor Wallace, President Johnson asked Governor Wallace to deploy the Alabama Guard, who were already recalled to state status, to deploy them to protect the marchers from the Selma to Montgomery marchers. All right, because they knew the march was going to take place. They knew when it was going to take place. And of course, they knew the march route, right? And so Governor Wallace refused to do it. So the Guard was already recalled. They were already on duty, but Governor Wallace refused to use them to protect the marchers from the backlash that everybody expected would happen in the communities that the marchers were going to walk through to get from Selma to Montgomery. And that's when President Johnson, without the consent or request of Governor Wallace, federalized the already active Alabama State Guard and told them, your job on this day at this location is to protect the Selma to Montgomery marchers from the threats that might come to them as they walk along this route. All right. I think these are the final slides. All right. This very long title, the Department of Defense Security for the Protection of the Department of Homeland Security Functions. This is the presidential memorandum that President Trump signed and issued on June 7th, 2025. This is the document that he is using as his invocation of authority to not only call up the California Guard and order them to do certain things in Los Angeles, but also to call up the active duty Marines from 29 Palms and order them to enter the bounds of the county or the city of Los Angeles. But as you'll see here, all of this discussion is talking about really the Department of Homeland Security, most notably ICE, right, Immigration and Customs Enforcement, and their performance of federal functions, including federal law enforcement, and that they do so including at federal locations, meaning federal buildings. All right, so he's trying very much to tie this particular call up of guardsmen as well as use of active duty forces to this notion that they're going to be protecting federal officers and they are going to be protecting federal buildings. It does cite 10 U.S.C. 12406 as his authority, but I've already showed you like how that's really insufficient for what he's doing here. The order also specifies at least 2,000 National Guard personnel for 60 days or at the discretion of the SecDef. That's an at least, it's not an at most, all right? That's a very important difference that it's at least instead of an at most, because there have already been 4,000 National Guard, California Guard activated under this order. It also says, you know, can employ other members of the regular armed forces. So that's where the Marines come into this picture. And notably, again, as many commentators have noticed already, there is no geographical time or other limitation on this. All right, there's an at least, there's not an at most. There's 60 days or at the discretion of SecDef, right? But nothing about this says California, nothing about this limits it to Los Angeles, nothing about this limits it to California Guard or to the Marine Corps stationed at 29 Palms. There is no geographical time or other limitation in this order. And so the only thing that would bound this order beyond what's written in it is the fact that if President Trump decides to cancel the memorandum, basically to revoke it, right? So that's the only way in which this authority or the citation of authority, which has a lot of legal problems with it, would go away. All right. So that is basically kind of the somewhat boring legal background of what JAGs and other people involved, especially federal government lawyers, those are some of the basic considerations that immediately spring to our minds when you're talking about the situation that has arisen in California. All right, so now, Shauna, fire away.
I have so many questions, Julie, and I know that there are so many in the chat too. I have a couple just that have just come to my mind while you were talking. First of all, wouldn't it be more beneficial to him to not federalize the Guard because then they wouldn't be underneath the Posse Comitatus Act? I mean, why is he federalizing them? It seems like it would be more beneficial to him to not.
Correct, and I assume it because in this particular case, he would never have gotten the California governor to request or consent to doing this.
Gotcha. And then I guess, a very common sense question, how is he doing this if he hasn't invoked the Insurrection Act?
So he was relying on Section 12406,
Right.
and he's also relying on this general notion that federal forces can be used to protect other federal officials as well as federal buildings. That is usually something that is left to law enforcement to do, obviously, federal law enforcement, right? So that whether it's in this case, like ICE officials or Customs and Border Protection officials being used to uh, um, both conduct immigration raids, as well as for CBP officers, if they're stationed at, let's say, an entry point into the United States, right, that they can both protect themselves, other federal officials who are present, as well as the federal building in which they are conducting their duties, right? So that's the general kind of idea that the legal concept that is out there and is generally in question. And so what President Trump is kind of tying these strings together into a knot by saying, oh, well, if I federalize guardsmen, then I can use them as federal officials in order to both protect other federal officials who are performing their job, which are these ICE officials conducting immigration raids, as well as to protect federal buildings like federal detention centers where supposedly, illegal immigrants are being held in detention by ICE or by DHS, really.
Okay. I'm going to ask you one more question and then I'm going to turn it over to the chat because we do have a lot of them. And this may be more your opinion, but I would love to know, many say that the military, and I'm probably speaking more to the deployment of Marines or the potential deployment of the Marines, would say that they are trained for war and not necessarily crowd control or de-escalation. And I think that raises concerns about the potential for actual escalation and unintended consequences. And I'd love to know your thoughts on that.
So yeah, this is not a part of the regular training of active duty military. It is a part of training for guardsmen in order to both to assist law enforcement and to be able to coordinate with them and communicate with them, as well as to assist them with things like civil disturbances, right? Which is kind of the military or guard term for like a riot or, incidents of violence or civil unrest, basically, right? And so I'm not going to argue that it's a huge part of guard training, but it is a part of guard training. It is built into their mission set that they should be able to perform this duty, or at least that some of them should be able to perform this duty at some point in time. Now, with active duty military, whether you're talking about infantry forces under the Army and Marines, or whether you're talking about some other kind of forces under the Navy or the Air Force or Space Force, I guess. I'm sorry to laugh. The idea that a Space Force guardian is going to run out there on the front lines should be scary to us all. Anyway, okay. Aside from that mockery of Space Force for a second, even for infantry, like Army infantry and the Marine Corps, because all of the Marine Corps is infantry, this is not a regular part of their training to basically respond to civil disturbances. So it's not like the Guard. So if you want to take any part of the active duty military and have us respond to civil disturbance, or heaven forbid, conduct civilian law enforcement, we have zero training. We have zero inherent capacity or capability to do that. All right. So that's why currently those 700 odd Marines have yet to show up on the streets of Los Angeles, because what the news reporting is they are somewhere. We don't know if they're still on 29 Palms or if they're in some like police facility somewhere in LA County. Someone is trying to jam a whole lot of just-in-time training down their throats so that they don't present a greater danger to themselves and the civilians around them, including law enforcement, as much as they're there to perform some duty, to protect some group of people. So that's why, you haven't seen the Marines appear yet, because the active duty military has no training to do this, because this is not a part of our mission set. So that's the difficulty here.
Yeah. Jennifer, do you want to ask some of the questions that are in the chat? Because I know there are quite a few.
Oh, I'm sorry, my mic was off. Kathy, do you want to go ahead with your question while I'm looking at these?
Yeah, could you talk a little bit about rules of engagement and whether the National Guard and the Marines would have the same rules of engagement, and what the rules of engagement in this instance are, if you know?
Yeah, so generally speaking, when the U.S. military, when we use the term rules of engagement, that's not just what you've heard in the movies. That's actually a very specific term of art for us that has a very specific definition and carries very specific connotations with it. First and foremost, it is for use in combat. We only use the term rules of engagement when we are talking about combat situations or situations that could result in combat, open combat. All right. So we do not use, even the Guard does not use some of them probably do, but they shouldn't. We don't use, formally speaking, we do not use the term rules of engagement or ROE when we're not talking about combat situations. All right. The term that we do use is rules for the use of force. All right. And rules for the use of force is also the terminology that you will hear law enforcement use for the situations in which they are authorized to use some amount of force, whether it's lethal force or even when it's non-lethal force. All right. We use the terminology RUF, RUF, or rules for the use of force. So rules for the use of force are what is being invoked in this particular situation, because it is not a combat situation. And what you're seeing play out, and I would say sometimes clearly violations for the rules of the use of force. Okay, an easy example I would give to you is that while I am not privy to the rules for the use of force, both by the California Guard in the particular situation, or even by the law enforcement organizations that are involved in this situation. Give me just a second. I have to turn on my power to my computer. Is I can tell you right now, when we have already seen on news reports situations in which LA Police Department have employed non-lethal munitions to respond to some of the protests or incidents of violence, I have already seen, because I know what the basic rules are for the use of non-lethal munitions, is that I have seen on the news violations of those rules. And I'm absolutely sure there are violations of the rules for the use of force, including non-lethal munitions, by folks like the LAPD, because they're well known to be limitations that have to be placed on something like non-lethal munitions to try and minimize their lethality. All right, so that's like a common. There are some things about the rules for the use of force, even for like active duty military, when we're not regularly engaged in employing them, we know certain basics about them that if they have to be invoked, that these are the circumstances in which they would have to be invoked. All right, so one basic situation which you would find in rules for the use of force for any law enforcement, well, no, I won't say that. Okay, a basic rule for the use of force that exists for like the Guard as much as it exists in the rules of engagement for a combat force in the US military is that you would only be able to use lethal force in situations in which someone is facing lethal force or the threat of lethal force. All right, so that's kind of like a basic premise of both the rules of engagement for the US military, as well as for the rules for the use of force that the Guard would be using currently. Is that there are the very basic notion that you can only use lethal force if you are confronted by lethal force or confronted by the threat of lethal force.
So would throwing a rock be considered lethal force?
Rock throwing can be a little difficult because it is circumstance dependent. All right. So if I'm a guardsman and I'm in full riot gear and I have my riot shield in front of me and someone throws a rock at me, that is not the use of lethal force. If I am driving under a highway overpass and someone pushes like a landscaping boulder onto my vehicle, that is the use, that's the threat or use of lethal force, right? Because yeah, so I can't say like, oh, rocks could never rise to the level of a threat of lethal force, because there are circumstances in which using a rock could rise to that level.
Julie, I want to go back really quickly just to follow up. You know, when you're talking about the Marines and they're not qualified, but not trained for this kind of deployment, do you think there is some internal conflict? I mean, I know the oath is foreign and domestic threat, but do you think this is a challenge for them because this is not necessarily a situation that they maybe ever saw themselves in?
This is not what they signed up for. I'm sure there are quite a few of them, including those who are from California, who are like, this is not what I signed up for. I think it will be, I'd likely win the bet if I told you there was at least 5 people from Los Angeles who are in that 700 Marines who have been called up, right? I am sure this is not what they signed up for. Because it is not something that is part of the active duty military's mission set and therefore not part of our training or whatever, it means that if we're put in that situation, that there is no doubt in my mind, not only that lawyers and commanders are working overtime trying to figure out how to direct their members to act in the various scenarios that they're going to face in the coming days, but also that they are all scrambling to figure out, like, no kidding, how do you perform this duty, right? I will say the questions about whether or not it is legal for President Trump to have done this or to do this is not a question that is being bandied around at kind of the basic action level, right? They are not involved in discussions right now about whether or not it's legal for President Trump to call up these 700 Marines and send them into Los Angeles. But there is no doubt in my mind, there is a lot of discussion about the legalities or illegalities of this situation happening at the lawyer and commander level currently. even now, even after you've sent the 700 Marines into a training status to get them ready to go into LA, I'm absolutely positive those conversations are still fast and furious.
Yeah.
That's consistent with a question that's in the chat. If a military person in this capacity has a moral objection to the overreach of power, do they have any option to not engage, or will these have to be followed?
They couldn't not go. All right. So if one of the 700 Marines says, "I'm from LA, are you kidding me?" Like, no, I'm not doing this. Like, that is not an option. They have received an order to deploy, to get ready to deploy, or to deploy into this situation. So if a junior Marine, if a junior enlisted Marine says, "I'm not doing this. I'm from LA. I am, no, I'm not doing it," then they basically are looking at the consequences of refusing an order that's been given to them.
Okay. Another question in here, in the case in California, the head of the state National Guard reports to the governor. Is that correct? In the
The
current,
state National Guard always reports to the governor as their commander in chief, as
okay.
long as they're in state status.
In the current situation, could the head of California National Guard refuse to comply with the incumbent's orders?
All right, so the major general, or the tag, or the adjutant general, who is in the senior military officer in the California Guard, as long as he's in state status and the governor is his commander in chief, if and when the state guard is federalized, called to federal duty, then his commander in chief becomes the president of the United States, and then the second in command is the Secretary of Defense. All right. So as long as he's in state status, he is subject to the orders of the governor. But once he becomes, and I say he because in this case it is a he, the tag of California is a he currently. As once he gets federalized, he's subject to the orders and commands of the president, and then the Secretary of Defense, and so on down the military chain of command. And in this case, because we're in the United States, it's Northern Command, based in Colorado Springs, but that's neither here nor there, right? And so once he's federalized, right, and he hears Governor Newsom is suing President Trump and Secretary Exeth because they did not, Governor Newsom in California, the state of California's claim is that the president lacked the authority to federalize the California Guard in this particular circumstance. And California and the governor of California want a court to enjoin them, to issue a temporary order to enjoin this federalization of the California Guard. Like the tag and the California Guard, while this is happening, until they get word of some, order from the court otherwise, they are in federal status and they are subject to the orders of the president and the Secretary of Defense.
Julie, someone just put in the chat that AP just alerted that a federal judge has said it is not legal for Trump to call on the National Guard.
All right. So then
Yeah.
the question will be is if that judge, because I know the suit was filed in the Northern District of California, so in federal court, but the question is, and maybe AP is also reporting this as well, did the judge issue it an injunction to stop or at least suspend the federal status of the California Guard? And if and when that happens, then the Guard stands down until we figure out what's going on.
It
Weird.
says it's
On
a
the current tense.
temporary restraining order.
It says that the judge says Trump illegally deployed National Guard to help with LA protests. He must return control.
And
To
there
the
was a
state.
follow-up order to that effect as well, because it's got to be beyond the ruling itself.
I
Yeah.
don't
So
know.
It says it's
So
a
yeah, so it's
temporary
the judge issues the ruling and then the judge issues an order, right, in addition to the ruling. And so as soon as that order comes down, if he says, I'm enjoining the President, Secretary of Defense from calling the California Guard to federal status unless and until the time that we litigate this further, basically, then the California Guard stands down or goes back to whatever it is that they were doing. Like their everyday lives, or I know some of them had already been activated because they were working with CAL FIRE in a guard status. So I think some of the 4,000 were already on duty as guards, state guardsmen, as part of the CAL FIRE initiative. But yeah.
So apparently it's a temporary restraining order from Linda Hutchinson said that. So
All right.
always evolving.
It is. It is. It's exciting.
All
It's
the
not so
big
exciting,
news
by
is-
the way, to be one of those guardsmen. Because what's happening is like, this is very in the weeds. And I'm not saying like national anybody, commentators, I understand why nobody's paying attention to this. But I will tell you, it's significant to those 4,000 guardsmen on the ground, which is that because President Trump, Secretary of Defense, called up these 4,000 guardsmen onto federal status without having any money behind that order, that is why you have seen pictures of these guardsmen like sleeping on floors of buildings and trying to figure out, like, when I walk down the street and buy my $10 Happy Meal at McDonald's, they are not on per diem right now. Like, there's no food coming to them. There's no place for them to bill it. There's nothing because, again, when the federal government federalizes a state guard force, there has to be federal money to pay their everyday living expenses and their wages while they're in that federal status. And there is no federal money that has been authorized yet for this.
Do you, and maybe you commented on this, but this is from the chat. Is it against the law to use the Marines against civilians? This has never been done before, correct? Is this unprecedented, deploying Marines to a U.S. protest or civil unrest?
I wouldn't purport to speak to any particular history of the Marines, but all of the instances, like the known historical instances, for the most part, of the past several decades, where you're like, oh my God, there's been a military clash in, somewhere in the United States, or something has happened between military and civilians, whichever line the law enforcement fell on, but between military and civilians somewhere in the United States, with the military operating in an official capacity. The only things I can think of in recent history, meaning, the past several decades, are instances that involved guardsmen. I can't think of a historical incident in the past, 50 to 100 years that involved an active duty military force inside the United States. But I'm happy to be corrected about that or asked about that.
Excuse me, I'm sorry, I couldn't raise my hand. Eisenhower called in, and I don't remember if it was the 82nd or the 101st Airborne to Little Rock, Arkansas in the 50s to protect the students.
Oh, good point. Yes, then I would have known that. So that's true. Okay. So what happened with Eisenhower was interesting because he, well, first of all, of course, Eisenhower was active duty military himself, right? So he obviously has a different thought about military than maybe certainly our recent presidents, perhaps. But I think the other thing that was happening there was, and I read briefly about this the other day, was I don't know that Eisenhower even asked the Arkansas governor about using the Arkansas Guard in that situation. I don't know that the Arkansas governor turned him down, or if he even coordinated with the Arkansas governor about the possibility of using the Arkansas Guard. But I will say, I do know Eisenhower did invoke the Insurrection Act in that particular instance. So once he decides to invoke the Insurrection Act, he's not limited kind of to the Guard, right? He can use active duty military, including for civilian law enforcement purposes at that point. So it could be that Eisenhower jumped so quickly to invoking the Insurrection Act that he didn't kind of have to pause along the way to deal with questions about the Arkansas Guard.
Kathy, did you have a question?
Yeah, assuming the temporary restraining order sticks on appeal, that only voids calling up the California National Guard. The executive order still stands, and that
It's not an
executive.
executive order, it's a presidential memorandum. I
Right,
know that
but-
doesn't sound like it matters, but it actually matters.
Okay, so does it stand? And am I correct that since it has no time limit, like 3 years from now, he can do this anytime, the whole time he's president? In any
So,
state?
yeah, I agree with you, your legal read that the parameters of a claim before a court, right, are limited to the parameters of that claim, right?
Right.
And since it's a California governor in the state of California that sued President Trump et al. In this situation, that the court's ruling, or very fast ruling, and temporary order only apply to the particular circumstances that the California governor and state of California raised. That having been said, as we both know, the appellate courthouse race is on, right? So this will fly through the Ninth Circuit, and very quickly it will become a question of whether or not the Supreme Court wants to take up the matter or not, right? And whether that would likely be off of the shadow docket or the emergency docket, whatever you want to call it. I can't imagine, first of all, it would surprise me if the Ninth Circuit took very long to make a ruling, right? Assuming that the Trump administration, DOJ, appeals both the district court judges' ruling and order, right? Because they're really appealing the order right away. That will go very quickly through the Ninth Circuit, I would suspect, so that the Supreme Court can decide what, if anything, they want to do with it. And of course, because I think it will move fairly quickly along that route, I think that timeline will move much faster than this coming up in a second state.
Okay.
Does that make sense? Like, so I say that fingers crossed that the Saturday events don't raise this in another location faster than the Ninth Circuit and the Supreme Court can deal with this. But yeah.
I'm gonna do Maud has a follow-up, and then I'm gonna have Maggie, Maggie wants a question. So Maud wanted to know, so if the current call-up and federalization is not legal, is there a reason why Trump is not using the Insurrection Act?
My guess is because as much I don't even know the right word for this, as much concern and response and churn as this set of decisions has generated, and where you already have a lot of people saying this is a red line that has been crossed, like this is like it only gets worse from here, right? This is a place from which we cannot step back. Like this is the unimaginable place for us, those of us alive in 2025 at least, right? Is that if this had happened and he had cited the Insurrection Act as the foundation of his authority, both to call up state guard as well as to use the military to conduct civilian law enforcement. Not only is that a legally completely weak basis to claim authority on, but also because it would even more cause like so much another whole level of uproar that we had crossed this line that significant portions of the American population or legal community or whatever would not be able to ignore or set aside as a oh, that's just a small situation and we don't have to worry about the implications of doing that.
Okay. Maggie Beveridge, did you have a question? You had your hand up and it's gone now. So I want to make sure that I'm not ignoring you.
I think my question was answered. Basically, it had to do with, could he do this in Pennsylvania or somewhere else on Saturday, right? Given especially, some court, because they'd be in a different
Circuit.
whatever
Right.
district. But then I thought, well, he's also going to be busy at his birthday party. So he might not be paying as much attention.
And it's not
Anyway.
until later in the day for
Oh,
Pennsylvania.
okay. Yeah.
All right.
So I don't know. I mean,
Yeah.
something could happen. Yeah. Okay.
Right. So we'll see. I mean, I think there are different situations that you could see arising where Pennsylvania might not be a great example in part because Pennsylvania has a Democratic governor, right? So
Right.
it is a blue state as much as it's voted for Trump in the past election, but it is under a Democratic governor, a very popular Democratic governor right now. I think not that I want interesting situations beyond what we're in right now, but I think if you wanted to say, well, let's think about, different scenarios, it would be because there are currently protests going on in Austin, Texas. And so the question is does, with Governor Abbott's consent, if President Trump federalizes the guard there, then he really comes into the problem of, shouldn't you have allowed Governor Abbott to call up the state guard in a state status so that they can do civilian law enforcement, rather than you calling them up in federal status where they can now not do civilian law enforcement, right? So that's that from a purely like esoteric legal standpoint, like that's more of the situation where like, but if you want to get around the Posse Comitatus Act, why didn't you just ask your buddy Governor Abbott to call up the Texas Guard in a state status?
Right. I guess I see him being more likely to do it in a blue state.
The many commentators are saying that he is looking to do these types, at least in terms of the immigration raids, to concentrate them in blue states rather than red states.
Right.
Based on the party of the governor in office. Not necessarily based on how the state voted in the last.
Oh, interesting. Okay. Oh
You
my
know what I'm
gosh.
saying?
Yeah, the club.
I don't know
Yeah.
what President Trump thinks of Pennsylvania. He might think of Pennsylvania as a red state because it voted for him, but
Right.
yeah, but I don't know.
Okay.
I'm going to do one more question because we are over time. I think we could talk about this all evening and it's always evolving, obviously, since it evolved while we were on the call. Julie, when, if ever, and this is from the chat, when, if ever, can a service member refuse an order, maybe on the grounds that this order is illegal or immoral?
All right, so I will put this more in the context of, for those of the members of the League of Women Voters of Arapahoe and Douglas counties, right? We had a discussion several weeks ago about the law of armed conflict. And we didn't talk about this particular issue, but there are two, they're not opposing thoughts, but they're two seemingly contrasting thoughts that military members have to hold in their mind when it comes to orders. First of all, if they believe that they have been given an illegal order, then they do have an obligation to refuse to obey it. All right. And the kind of classic example the military as well as US civilians tend to use is the massacre at My Lai in Vietnam, right? Where those junior enlisted soldiers were given what should have been obvious to them. And again, I'm saying this based on how we talk about it today, right? I mean, I can't put myself in their position necessarily, but how we look at it today is we say the illegal nature of the orders that they were given to line up women and children in a ditch and shoot them all, right? That was patently illegal on its face, and that they had an obligation not to obey that order, right? And when they obeyed it, they obeyed an illegal order. And then you have the other thought that we do instruct our military members on, and it's actually captured in the Uniform Code of Military Justice with regards to obeying or disobeying an order, which is that military orders given in a legal fashion, meaning that a superior officer has issued it, is that, and it is clear and concise and understood, is that those are presumed legal, right? So like even the most junior enlisted member in a unit is instructed on those two ideas, that if you believe you have been given an illegal order, you have an obligation not to obey it. And orders given legally, meaning by superior officers that are clear and understood, are presumed to be legal. So that's what we put in front of them. And then we say, hey, if you think you are in a situation, whether because you are questioning an order that you have been given, either because you don't think it's clear, or you don't think you understand what your superior officer ordered, or because you think you've just been ordered to do something that is illegal, is we give them all the roots to raise that concern. So we don't leave them to decide on their own. We say, all right, here are the different channels you go to if you find yourself in that situation. You go to your lawyer, you go to a chaplain, you go to an inspector general, or, and this, I know this is going to sound crazy to all, you call your congressman. Like, we no kidding drill them on the avenues they have to pursue questions or concerns about orders that are given to them. So that's how we deal with that situation.
Fascinating. Well, this whole evening has been so informative and so helpful. And I think like I said, I think we could talk all night, but we're well over. So I just want to say thank you to everybody. Everyone hung in there. Julie, many, many thanks to you for all this information. It's been helpful. And I know personally I'll be reaching out to you a whole lot because you are obviously a font of knowledge. So everybody, thanks for joining us tonight. And with that, we'll say goodnight.
Thank you.
Phenomenal job, Julie.